Hello friends, on earlier occasions we have talked on various topics of human rights. Today we will talk about torture and other degrading treatment. Despite state prohibitions against torture and custodial misconduct by police, torture in police custody and prisons goes unabated in India. Deaths in police custody are reported at regular intervals. These deaths are often shown as suicides, self-inflicted injuries and natural deaths. Forced confessions are extracted using torture on the accused. The witness statements and the recovery under Indian Evidence Act is developed to suit the confession statements. The police officer who engages in custodial violence is rarely brought to justice. There is no independent agency in India which can effectively investigate crimes committed by law enforcing agencies. These lacunas in the existing justice delivery system are often misused by the law enforcement agencies in India, particularly by the police, to commit the acts of torture and degrading treatment. Defines torture as the infliction of intense pain to the body or mind to punish, to extract a confession or information, or to obtain sadistic pleasure. Webster Third New International Dictionary of the English Language defines torture as the infliction of intense pain as from burning, crushing, wounding, to punish or coerce someone. Similarly, Oxford American Dictionary and Language Guide defines torture as the infliction of severe bodily pain, especially as punishment or a means of persuasion. Article 1, Clause 1 of the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment provides torture to mean any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or a confession, punishing him for an act he or a third person has committed or is suspected of having committed. Degrading treatment has been defined by the European Commission of Human Rights as treatment or punishment that grossly humiliates the victim before others or drives the detainee to act against his or her will or conscience. Degrading treatment or punishment arouses a feeling of fear, anguish and inferiority and humiliates and debases the victim. Now let us talk about essential ingredients of the act of torture. Intensity of pain or suffering inflicted. In order to constitute torture, the pain or suffering must be of a severe nature. According to the dictionary meaning, severe pain means extremely violent or intense, severe pain, grievous, extreme and of circumstances hard to sustain or endure. It could be physical or mental or a combination of both. Purpose of inflicting pain or suffering. Obtaining information or a confession for any reason based on the discrimination of any kind, or it could be for deriving sadistic pleasures. Involvement of public official. The torturer is a law enforcement official or member of the security or intelligence services. It may also be someone with no official status but acting in collusion with civilian political authorities, or where the act is carried out by the person having no official status against which the law enforcement or security officials turn a blind eye to the excesses. Prohibition of tortures and degrading treatment under the constitutional and other laws of India. Article 21 of the Constitution guarantees the right to life and personal liberty and thereby prohibits any inhuman, cruel or degrading treatment to any person. Though torture is not criminalized in law as a separate or special offence, but it has been prohibited and discouraged in various laws. Provisions in the Indian Penal Code 1860 penalize acts that can also be considered as torture. Section 330 of IPC penalizes the voluntary causing of hurt for the purpose of extorting from the sufferer or from any person interested in the sufferer any confession or any information which may lead to the detection of an offence or misconduct. Section 376 clause 2 of IPC penalizes a police officer guilty of committing rape within the limits of the police station to which he is appointed, or in the premises of any station house whether or not situated in the police station to which he is appointed, or on a woman in his custody or in the custody of a police officer subordinate to him. Under Section 25 of Indian Evidence Act, the evidence collected by illegal means including torture is not accepted in courts. Now let us talk about international instruments which prohibit torture and degrading treatment. Universal Declaration of Human Rights, 1948. This fundamental UN human rights document asserts that no one shall be subjected to torture or to cruel, inhuman or degrading treatment or punishment. Several provisions of the Universal Declaration of Human Rights have become a norm of customary international law. Customary international law is universal in the sense that its obligations bind all nations except those that persistently object during the development of the norm. Torture is consequently prohibited by the international customary law during the times of armed conflict and during the times of peace. International Covenant on Civil and Political Rights, 1966. Torture is prohibited under the Covenant and states that no one shall be subjected to torture or to cruel, inhuman or degrading treatment or punishment. Article 4 provides that Article 6, under which every human being has inherent life, and Article 6, which prohibits torture, cruel and degrading treatment, cannot be suspended or limited even in times of emergency. In times of public emergency which threatens the life of the nation, and the states may take measures derogating from their obligations under the present covenant to the extent strictly required by the exigencies of the situation, provided that such measures are not inconsistent with their other obligations under international law and do not involve discrimination solely on the ground of race, color, sex, language, religion or social origin. Declaration on the protection of all persons from being subjected to torture and other cruel, inhuman or degrading treatment or punishment, 1975. Any act of torture or other cruel, inhuman or degrading treatment or punishment is an offence to human dignity. Every state shall take effective measures to prevent torture and other cruel, inhuman or degrading treatment or punishment from being practiced within its jurisdiction. Exceptional circumstances such as a state of war or a threat of war, internal political disturbance or any other public emergency may not be invoked as a justification of torture or other cruel, inhuman or degrading treatment or punishment. Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, 1984. Under Article 20, if the committee constituted in this context receives reliable information which appears to contain well-founded indications that torture is being systematically practiced in the territory of a state party, the committee shall invite that state party to cooperate in the examination of the information and designate one or more of its members to make a confidential inquiry and to report the committee. All proceedings are confidential. The committee can consider communication by or on behalf of individual and by the state party concerned. The committee shall not consider any communication from any individual unless it has ascertained that individual has exhausted all available domestic remedies. Optional Protocol to the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, 2002. The objective of the protocol is to establish a system of regular visits undertaken by independent international and national bodies to places where people are deprived of their liberty. In order to prevent torture and other cruel, inhuman or degrading treatment or punishment, each state party shall set up, designate or maintain at the domestic level one or several visiting bodies for the prevention of torture and other cruel, inhuman or degrading treatment or punishment. When visiting a state party, the members of subcommittee on prevention shall respect the laws and regulations of the visited state, refrain from any action or activity incompatible with the impartial and international nature of their duties. Members of the subcommittee on prevention and of the national preventive mechanisms shall be accorded such privileges and immunities as are necessary for the independent exercise of their functions. We now will be talking about the role of National Human Rights Commission. Under Section 18 of the Protection of Human Rights Act, the National Human Rights Commission has the power to recommend monetary compensation to the victims of human rights violation and to initiate proceedings for the prosecution of the guilty public officials. The National Human Rights Commission regularly awards monetary compensation. It has identified custodial deaths and rapes as a priority area of concern and issued instructions to all states and union territories to report any instance of custodial rape or death within 24 hours of its occurrence. It later held that all post-mortem examinations done in respect of the death in police custody and jails should be video recorded and sent to the Commission along with post-mortem report. The National Human Rights Commission undoubtedly has some achievements to its credit in terms of its efforts to make the police accountable for their actions. However, Commission's work has suffered due to certain infirmities and deficiencies in the law governing its operation. The National Human Rights Commission has been denied a mandate to investigate human rights violation by the armed forces under Section 19 of the Protection of Human Rights Act 1993 as amended in 2006. The law obviously weakens the National Human Rights Commission's effectiveness in providing redress to the public in cases where violations have been committed by the members of these forces, which are often deployed on law and order duty in disturbed areas. All that the Commission can do in these cases under the Protection of Human Rights Act is to call for reports from the central government and make recommendations to the government. Now let us talk about the judicial response against torture and degrading treatment. The Supreme Court held that the public hanging would violate Article 21 of the Constitution, being barbaric, disgraceful as seen in any civilized society. In Sunil Batra etc. versus Delhi administration and others, the jail superintendent was directed to ensure that no corporal punishment or personal violence was inflicted to the prisoners. It was further held that the superintendent cannot absolve himself from the responsibility even though he may not be directly a party. Prisoners are persons and not animals, and the divine guardians of the prison system shall be punished where they go berserk and defile the dignity of the human inmate. In the case of Charles Shobraj versus the Superintendent, Central Jail, Tihar, it was observed by the court, like you and me, prisoners are also human beings. Hence, all such rights except those that are taken away in the legitimate process of incarceration still remain with the prisoner. These include rights that are related to the protection of basic human dignity as well as those for the development of the prisoner into a better human being. In Prem Shankar Shukla versus Delhi administration, the rules, regulation and manuals of various statutes authorizing the police to use handcuff have been struck down as violative of Article 14 of Indian Constitution. Supreme Court held that the person cannot be handcuffed only because he is charged with grave offence or for the convenience of the escort party. In TV Vathishwaran versus State of Tamil Nadu, the dehumanizing effect of prolonged delay in the execution of a sentence of death arose for consideration. It was held that a prolonged delay, when it arises from the factors outside the control of the condemned person, can render a decision to carry out the sentence of death an inhuman and degrading punishment. Just to sum up, we can say that any form of torture or cruel, inhuman or degrading treatment would fall within the inhibition of Article 21 of the Constitution, whether it occurs during investigation, interrogation or otherwise. If the functionaries of the government become lawbreakers, it would encourage lawlessness and every man would have the tendency to become lawbreaker, thereby leading to anarchism. No civilized nation can permit that to happen. The existing mechanisms of accountability must be strengthened and improved. In addition, new mechanisms working independently to monitor the operations of the police and inquire into public complaints against the police must be established. Domestic legislation to give full effect to the obligations arising under the Convention Against Torture and other cruel, inhuman or degrading treatment or punishment should be enacted. The performance of the police as an institution and the behavior of the police personnel as individuals both need constant monitoring.